Or Lankford.
Mr. Chairman, thank you. Thank you to all of you that are here. It's nice to see so many Oklahomans here and get a chance to hang out with neighbors. And very much appreciate your testimony, and for everyone coming today. Especially want to be able to thank Principal Chief Hoskins, Chief Johnson for coming here to be able to represent in leadership. All of you have done a great job representing your tribe, but I especially want to recognize the two chiefs that are here as well. Also for Marilyn Van, we met, I'm trying to think, 11 years ago. When you chased me down in a town hall meeting at a public library and cornered me in the room to talk about freedmen issues. Right. And we're tenacious about that and has never stopped in the process. So you represent the freedmen well. You have stayed very knowledgeable on these issues and have stayed tenacious in the process on that. So it's great over a now decade-long friendship with us that we have stayed in contact since then. You didn't scare me off when you cornered me in the room to be able to talk through issues, and you still don't scare me off. And so glad to be able to call you a friend as well. Let me just ask a general question on this and to just bring this out, because the chairman's trying to be able to figure out how do we get to resolution so this is not another century from now and this same kind of hearing is still occurring? Because many of you referenced these are resolved issues within our tribe. It's been resolved in law. It's been resolved through different treaties. It's been resolved through different arrangements. But it's clearly unresolved in some of these issues. So the key becomes, how do we actually get to resolution on this? So can you describe to me the relationship and the number of freedmen that are connected to the tribe that we know of? As you mentioned before, Chief Hoskins, about 12,000 at this point for the Cherokee Nation. The number, and then also what is the current relationship there, whether it is voting rights, whether it is other benefits, or whether it's nothing at all. And that would be helpful just to be able to get some context for the record on that. Chief Hoskins, obviously yours is the easiest of this one, but.
Yes, thank you, Senator. It is good to be here and to spend some time with you. At Cherokee Nation, citizenship is equal. I suspect my good friend Marilyn Van has the same thing with her that I have with me, which is a Cherokee citizenship card, which, apart from our picture and name, is indistinguishable. That's where it starts in terms of the symbolic representation of citizenship. But beyond that, there are equal rights. There are no distinctions between Cherokee citizens of freedmen descent or Cherokees by blood descent. I would note for the committee that Cherokee Nation is even more diverse than that. There are Cherokee citizens of Shawnee descent, Cherokee citizens of Delaware descent. Those all stem, Senator, from that same time period, the period of post-Civil War. There is no distinction. I do want to note, if I could take the opportunity, my friend Marilyn Van noted those two areas in which Cherokee citizens of freedmen descent do not have equal access. Those are two distinctly federal issues for which the Cherokee Nation would support any discussion, any dialogue on how to repair those. Those are not within the control of the Cherokee Nation. So to the extent, Senator, that it's within our control, equal rights is the order of the day at the Cherokee Nation.
Okay. Chief Johnson, it's good to see you.
Good to see you.
So do you have an accounting of what that number might look like for freedmen that are attached to the Seminole Nation or in a relationship there, and what that relationship is like?
The freedmen are numbered within the Seminole Nation citizenship, about 2,500.
Okay.
And I want to say some things on some things that's just been what I call innuendos and things. If anyone here has studied the history of the Southeastern tribes, what you're going to find is that the Seminoles are totally separate in the areas of the relationships with people of persons of African descent. My land's, the longest wars in American Indian history was fought between the United States, the Seminoles, and what they were called the Maroons. Some of them were escaped slaves, some of them were free people. That was freedom fighters that were fighting for the same cause, and that was to remain free. The Seminoles have always had the freedmen as their citizens since 1866. We had a Florida lands claims not too long ago, back in the 1990s. That was as a Seminole nation was recognized by Congress in 1823. The freedmen was not, the so-called freemen at that time was not actually freemen. They were persons of African descent, Maroons, free slave, or escaped slaves from the South. So they were not eligible for those judgment funds as deemed by Congress. Now, what we know as Seminoles is that since 1866, the freedmen have been citizens. They got 2 seats on the tribal council, which is 4 seats on the tribal council. They can vote on measures that's passed by the tribal council of the Seminole Nation. If they come in for enrollment, they come in and they are enrolled as citizens. You know, customs among American Indians are very important. Now, I hear all kinds of words being said this day, but my land, our treaty says that the terms of the 1866 treaty made it clear that said legislation shall not in any manner interfere with or annul the present tribal organization, the rights, the laws, the privilege, and the customs. It has always been the custom of the Seminole because the treaty says so. It says right here in the treaty that, that its members are citizens. We had that choice to say members or citizens. So I see interchangeably that term being used, citizen, members, citizenship, membership, all that type of thing. And that might work for federal government, but in the customs of the Seminole Nation of Oklahoma, freedmen and the descendants of the freedmen, there's no such thing as a freedman today. I think you know that. They're descendants of freedmen. And they have always been, by custom of the Seminoles, the Seminole Indians have been members of what? Of the native bands, the 12 different native bands within the nation, and once after 1866 and the development of the freedmen bands, they have been members of those particular bands as well. But they have always been seen as citizens. And the customs of the Seminoles that became the specific tribes in Florida that became known as Seminoles, we have always been known as the members of those specific bands and that's in the Seminole Nation. So that's how the Seminole Nation sees it. That's our oral history. That's our tradition. And I believe the treaty actually supports those two terms being used. And that's how the Seminoles use them in this present day as well.
Thank you, Chief Johnson. Michael Burridge.
Yeah, thank you, Senator. With regard to a path forward, well, before that, I don't have a number to give you.
Okay.
Maybe we can get that, but I don't have a number to give you. But with regard to a path forward,
it's not so much a path forward as it is just a description of the current relationship as far as services. What may be different on that?
The Choctaw Nation does not recognize the freedmen.
Okay.
And that is because of the Constitution. But just one brief word on that Constitution that arose in federal court. The Department of Justice and the Department of Interior were in that case. There was specific discussion about how certain people would be treated, the adopted, the intermarried white, and the freedmen.
Right.
And a determination was made that it wanted to be Choctaw by blood. Delton Cox from Poto, Oklahoma was on that commission. And I've talked to him, and he said this specific issue was discussed, and the federal government never raised an objection. They never raised the treaty issue. They never raised the freedmen issue and approved this Constitution. We think that Choctaw Nation as a sovereign entity should be able to determine its memberships as set forth by the Supreme Court.
Okay. Thank you, Mr. Burridge. Thank you. John F., I'm going to call you by your first name because we already know each other. So, yeah.
Yes, sir.
So give us the approximate number that's in a relationship if it's known, and then any other benefits or details or connection.
I don't think specific numbers are known because the data is notoriously challenging to confirm the validity of. And along those lines, Creek Nation has been engaged in an active effort to compile data internally and collect historic, cultural, legal information to help provide background for citizens of Creek Nation to have an informed dialogue that's driven by facts, not by political rhetoric. And that informed dialogue, incidentally, may go beyond any specific treaty provision. I want to point this out because the treaty issue is it's been framed in very conclusory terms about what it says and what it doesn't say. But as I've said before, the treaty itself is working its way through our court system. But beyond that, this information gathering that our chief, Principal Chief Hill, has promoted as part of a national conversation will help inform conversations beyond simple treaty interpretation. Any nation worth its salt has to, including the United States, has to regularly determine whether or not existing laws are consistent with the will of the people. And you need information, you need data to have that discussion. But I would just say, in a previous position, I was at an agency that cited regularly a statutory provision that is often cited in many watershed legislation in terms of Indian affairs. And that legislation talks about the fundamental policy goal of the federal government is to support strong tribal governments. So whether it's through the judicial process of Muskogee Creek Nation or the public voting process of Muskogee Creek Nation, the federal government has a responsibility to support the sovereignty of the nation as it engages in this dialogue. It's important that it does so because, as I said before, colonialist history does not bode well in terms of efforts by the United States to impose its values on these sovereign nations. And we need to learn from history. So one way to turn sympathetic folks in this issue against a federal action is to impose solutions rather than have a true healing process within the nation that's fostered by information. And that's what we're engaged in right now at Muskogee Creek Nation. People may have concerns about timeframes. People may have concerns about when things are going to happen. But any progress of any nation comes in its own time. Yes, we need to push for a conversation, but it can't be imposed by the United States. So thank you, Senator. Your question about data is very well taken. There are historic problems with the data, but we're internally looking at it. I caution against conclusory positions regarding what one treaty provision means without having the courts take a look.
I get that. Respect that. That's the area that the chairman's been working on for a while and trying to be able to think through how to be able to gather more data. The work that the Muskogee Creek Nation's already done will be very helpful in that process to be able to be informative for a process like that. So that's a helpful piece to be able to have. So I appreciate that very much. And what I think you hear from this committee and certainly from the chairman is how do we work together in this process? I don't hear a federal action to be able to try to step on any kind of tribe in that. It's getting a chance to be able to partner together for things. Mr. Gretham.
Thank you.
It's just to define terms. Chickasaw Nation doesn't track freedmen or non-freedmen. There's Chickasaw citizens and non-citizens. As I said, this was litigated over a century ago, so there aren't separate tracks of citizenship. There are just citizens. Many Chickasaw citizens are also folks who are descended from people who were held in bondage. So they could be classified as freed persons, but they're also on the Chickasaw by blood roll, so they count as citizens. I have no number for you as far as folks who are not on the Dawes Commission Chickasaw by blood roll, but are exclusively on the Freedom roll. I have no number for you on that.
Okay. All right. That sounds very good. Mr. Chairman, I'm going to ask one follow-up question on it. So I apologize for going long. I'm taking my Oklahoma time with Oklahoma folks here in the process, but that's helpful. Thanks for just putting the context of that on the record because that's helpful to be able to get the context on all those issues. Mr. Newland, I do want to ask a slightly separate question on this just as a follow-up on it. There were two major Supreme Court decisions that have a very direct and immediate impact on Oklahoma. You know them very well as McGirt and the Castro Huerta decisions on that. I need to ask you a question. If the Department of Interior or if you or anyone you know of is currently working on a legislative response for McGirt or for Castro Huerta, is there any ongoing work either from technical assistance or writing? Because this has direct impact on every person that's here and on my state and the 4 million Oklahomans that I represent. So is there any action that's currently going on that you or anyone on your team working on to develop a legislative response to Castro Huerta or to McGirt?
Thank you, Senator. The executive branch has been asked to provide technical assistance on legislative language in response to the Supreme Court's recent decision.
Okay, was that only on Castro Huerta or was it McGirt as well?
Yes, Senator Castro Huerta.
Would you be willing to be able to share that in my office as the senator for Oklahoma? Obviously, that has the direct impact on my state as well and all these folks that are here.
Pardon? Can you?
Would you be willing to be able to share that information with me? Because obviously, as the senator for Oklahoma, that has direct impact on my state.
I don't see a reason why, no reason comes to mind why we wouldn't be able to share that, Senator.
Be great. Thank you. Mr. Chairman, thank you.
Thank you. Senator Lankford, just on the question of TA, I don't know who the TA is being provided to actually, but I just want to make sure that they have if it's a member or a member office or a committee office, I want to make sure that they have the ability to work confidentially with counsel and the executive branch. But I can assure you that the conversations we've had privately about understanding that Oklahoma equities are well taken. But I just want to protect Secretary Newland's ability to work confidentially with whatever member or member office may be asking for TA.
Sure.
In fact, it could be my staff. I don't know yet.
I respect that. My biggest challenge is I don't ever want something being worked on or developed that's a piece of legislation that has direct and immediate impact on Oklahoma tribes and on the state of Oklahoma, and Oklahoma not actually be involved in that.
Nothing about me without me. I got it. Thank you very much. I just have one final question for Ms. Van, and I've lost it. Oh, got it. Knowing that Congress's authority related to tribal membership is limited by federal Indian law and the language of the treaties at issue today, what do you think can be done to further the cause of reconciliation? I think that although it got a little hot today, and I have no doubt that some people will leave this hearing, maybe even most people will leave this hearing feeling unsatisfied, not vindicated. I consider this a success because we aired it out, and people were heard. And I think it is important to move forward, but I think it is important to move forward carefully. Measure twice, cut once. We want to make sure that we move forward legislatively together. We want to make sure that sovereignty is respected, but we also want to understand that African-American enslaved people and Native Americans were mistreated. And we are all in this situation because of the actions of the federal government of the United States. The official policy of the federal government of the United States ends up pitting African Americans and Native Americans against each other in this terribly unfortunate historic circumstance. And so I don't have an easy solution. I think a GAO report is a reasonable start. I think dialogue is an important start, but I'm open to whatever suggestions you may have about moving forward as quickly as we can, but understanding that if we try to move too quickly, it will actually backfire and we will lose another decade of potential progress. So I'm interested in your thoughts, Ms. Van.
Thank you, Mr. Chairman. I am, as a member of a tribe, I am, certainly I believe in tribal sovereignty, but the United States, of course, does have a responsibility to the freedmen people as per the treaty, not just to the tribal chiefs and chairmen. Now, decisions have been made regarding the status of the freedmen by some tribal nations, and this comes in part after, Jim Crow laws, which put the persons of African ancestry on the bottom of the deck here in Oklahoma. So far as solutions moving forward, where there are some the freedmen have tried to do various things to try to get equity under the treaty. As I said, for instance, there are some Creek freedmen descendants who have been trying to use the federal courts and also the tribal courts, as well as, of course, coming up here to D.C. We would like for the true history of the tribes and the freedmen to be there. So as I said, that's one reason we're calling for studies, because there have been some tribal leaders in the past who have said things like the freedmen were forced on the tribes or snuck in from Arkansas, although there are federal records that say otherwise. So let's get the truth out there for what it is. So far as I like this idea of continued dialogue, but as I said, the freedmen people, a lot of people are in need. Not all of that is the fault of the tribes. Some of that is the state of Oklahoma. And there were some tribal leaders in the past that were in elected position. I think there was around 1907. There were some that were that were coming from some of the tribes that sat in Congress, that sat in the Senate, and they were opposed to persons of African ancestry. I also want to mention that the freedmen people were not citizens of the United States until the other members of the tribe became citizens. Our citizenship was coming through the treaties. Now, so that being said, I made a few suggestions about, possibly how the United States can bring some relief to the freedmen people, so far as some services. I know all of that's going to cost money, but I also want to mention the fact that back in those earlier days, when the tribal governments were more limited, until the Principal Chiefs Act was passed in 1970, the Bureau, they did number people, including the freedmen people, sometimes for per capita payments. That happened, I know, in the Cherokee Nation. I know in the Creek Nation, there were some per capita payments in the past. And so this sort of thing can be done, but again, it's going to cost some money. I get that. In my 22-page report, I have some other suggestions there. Again, we couldn't get to in the 5 minutes. So that's what I'm thinking. It's going to take some time, some effort by the federal government. I would like to, and I understand that there were constitutions that were approved by the federal government, but if freedmen people weren't allowed to vote on them, well, and again, they've been signed. So there we are.
Thank you very much. I'll thank all of the testifiers as well as our first panelist, Chair Waters from the U.S. House of Representatives. The hearing record will be open for 1 month to allow ample time for views to be submitted for the committee's consideration. I want to thank all of the witnesses for their time and their testimony today. This hearing is adjourned.
Thank you.